My lord. My lord, with the consent of my senior friend, my lord, I'm
Yes.
mentioning item number 16 and 17, my lord. I was supposed to file an affidavit here, my lord. I have sent it for vetting.
16, 17.
16, 17, my lord. It will take some 2-3 days, my lord, to affidavit to come back, my lord.
On the prayer of, no, Mr. Arthur, learned standing council, emblem textile, emblem, textile and civic council. The Mr. He has sent the affidavit for vetting. Therefore, press listing of the matter, press for adjourn of the matter for 2 weeks.
Yes.
We are not been objected to by the council. Must be Petitioner, land council for the petition. Please, after 2 weeks, so as to enable him to file. So as to enable the clandestine council to file affidavit.
Deeply, President.
May I please, Your Lordship, I beg to mention item number 22.
22.
Yes, there is an additional affidavit to supposed to be filed, but registry has asked for the defective on the additional affidavit for substitute of the petition.
Okay, on the prayer of Mr.
I
Therefore,
will
petitioner,
petitioner,
Mr.
B.N. Gogol.
Doctor,
Lordship.
Dr. B.N. Gogol, land council for the list this matter after 2 weeks. 2 weeks.
Lordship.
May it please, Your Lordship. Mr. I'd like to mention item number 11, Your Lordship.
11.
Yes, yes. I'm for the respondent bank. In this case, Your Lordship, the original records were called for, Your Lordship. I need some time to bring it on record, Your Lordship.
Personal difficulty
Due to some personal
yesterday.
difficulty.
I mean, he had they informed me today. His junior got had an accident, so he could not get the records. The
So
volume.
we'll release from Padad because I will be away for 4 or 5 weeks. Heard Mr.
Ajay Das.
Das land council for the petition. Mr.
H. Buragan, Your Lordship.
H. Buragoy, learned counsel for the respondents submitted. He could not obtain the
original records.
original record. Mr. Therefore, fresh for listing of the matter after 3 weeks.
No, Lordship, 1 week a date may be fixed. I'm under the pension is
2
at
weeks,
whole
2 weeks.
so any date may be fixed, Lordship. I
Praise
pray.
the Lord, list the matter after 2 weeks.
Date may be given, Lordship.
List the matter was heard in part, however. But, no, the list matter was heard in part. However, since the parties have expressed urgency, same is released from part.
Lordship, a date may be fixed.
Just after 2 weeks.
Obliged,
DPO.
Lordship.
May it please your lordship. Lordship, I beg to mention item 18, 19, 20, and 21. Lordship, we have been recently engaged in this matter. We had filed a reply yesterday, Lordship. Let it come on record, Lordship.
18, 19, 20, 21.
Lordship may fix it after 2 weeks or any day.
MS
D. Mohanto.
D. Mohanto,
D.
Land Council, D.
Diksha D.
D. Mohanto, Land Council for the Land Council submits that she has been engaged recently by the petitioner in this matters. Stop therefore, listing of the matter after 2 weeks. Prayer allowed. List after 2 weeks.
Much obliged, Lordship.
We have put a respondent, Lordship.
Have you paid? Have you released?
Lordship, earlier, one amount already released,
No,
Lordship.
no,
And
earlier we are not.
remaining 51, I have the check, Lordship. And yesterday I contacted the council for the petitioner, Lordship. He informed me that he will take today.
It's finished.
Yes.
So, matter
So,
ends.
the matter ends, Lordship.
Closed.
Yes.
Okay. We'll not say all this thing, huh?
Yes, sir.
We'll not recording it.
Yeah.
It doesn't look nice. You would have exchanged it in the.
Yes, Lordship, but yesterday,
Outside the phone.
yesterday I contacted and today also I tried to call. But
Anyway,
yeah, I think written by learned counsel, he is.
MS so and so learned counsel for the petitioner submits that the grievance of the petitioner has been addressed by the respondents by now. So we're closing it, huh?
Yes.
Mr. So and so learned counsel for the respondent.
Just one.
Is present. In view of the above, written stands closed. And disposed of.
Hello.
This has become, in view of the prisoner has become infruction accordingly, same is closed. Yes,
Lordship, we are filing the affidavit in the course of this week.
okay.
Lordship may keep it next week, Tuesday, anytime next week. We received the,
What is the matter?
Lordship, that is the 3F appointees.
Okay,
We moved in 4 IAs, 3 IAs, because we were apprehending they'll release us. But
Next.
My learned friend has-
Coming Tuesday, Lordship.
coming soon.
Coming
Okay.
Tuesday.
you
Tuesday, no?
want to file some affidavit?
Yes,
Uh,
I rejoined the,
Reason that,
yes.
affidavit in reply.
In reply.
MS, D. Goswami, learned counsel for the petitioner, petitioners.
Thursday, could you do?
Tuesday.
Submits that. She may be granted a week's time to file affidavit in reply.
Thursday, go.
No, the
Manish, go ahead. Go ahead.
Mr. K. Roy, learned Standing Council Higher Education Department has no. Wednesday.
Wednesday.
Accordingly.
List this matter after a week,
Lordship,
so as to enable.
On 11, Lordship, we have some difficulties on 12. Lord. So,
11.
We go some.
11 to kill, Monday only.
No, no, 11 to Wednesday. Figure, sir.
List on 11.
11. Lord.
Obliged, dear Lordship. Obliged.
Up to 5. Up to 5.
May I please, Lord?
Yes.
My lord, in this matters, my lord, we are challenging the variation based, my lord. My lord, I'm praying that lordship is
List
kindly.
for hearing.
Yes, lordship.
Yes,
The readings are over.
For hearing,
Yes, for hearing.
reading is already completed, madam.
And Mr. So and so.
K. Vishwakarma.
Counsel for the petitioner. And Mr.
BPC,
BPC, learned counsel. Stick,
No, my lord, I will respond that.
who is for state? Mr. K. Roy for Standing Council.
Six and seven.
Which department? Which department?
Whom, my lord?
Yes. Mr. So and so. You pay go for state council for the respondents and Mr. So and so for
BPC.
for respondent number 8. Respondent number 8.
I am. I have all the private respondent, my lord.
Private respondent number? All the private response, huh?
It is
Who? Admitted petition, petition is admitted, this for hearing after 2 weeks.
My lord, can a date be fixed, lordship?
2 weeks.
After 2 weeks. If a date be fixed, that will be,
It's okay, seniority matter.
my lord, there is an interim order, lordship. That may be,
Pass, I'll just continue.
I'm obliged, my lord.
Obliged.
May I please, Your Lordship?
Yes,
Lordship, here we were asked to produce record, but we have not received it yet because of our communication delay.
what is the what is the matter?
So regarding service,
Huh?
reinstatement.
Reinstatement, okay.
Lordship, kindly.
MS so and so learned council for the petitioner.
Next,
On the prayer of MS so and so learned
escape right?
Kempai.
Yes, Lordship.
4.
Respond number 3, 4, 5, and 6, KAC, Lordship.
List this matter. After 3 weeks, so as to enable her
Lordship,
to
short date, Lordship.
place the records.
Obliged, Lordship.
Yes, Lordship. That matter, day before yesterday, Lordship has already had this matter.
Yes. What is the matter?
That matter, Lordship, regarding termination regarding Lordship due to hiding Lordship affidavit.
Yes,
That matter. Already Lordship has agreed to.
false affidavit.
Yes.
Yes. Where is Mr. Goswami?
That's very much. Yeah, no.
Fix this matter that he wants to place some judgment.
Yeah, that's fine.
Lordship, can it be taken up on Monday, Lordship?
Why?
Because he has some medical issues today, Lordship. That's why he is not present.
Who wanted to dispose of the matter? If it's in medical, what can? So what to do? Your medical, he has some medical problem. In fact, that day we this court
Or
want to dispose-
Lordship may take it after some time so that I can go through.
Let us see. Yes,
They are supposed to be instruction regarding rule 26.
yes. Who is that? Todi. S Todi.
Yes.
It's a bank or what?
No, my lord. It is regarding,
NEPCO.
yes, yes. My lord, he was not in service for 10 years, 9 years, my lord. Then he submitted resignation, challenged that acceptance of resignation, High Court set aside. Accordingly, he was allowed to join in late stage, my lord, in 2000.
You want the subsistence allowance
Yes, yes. It was, yes.
for a period of
Yes,
your
yes.
suspension, subsistence allowance?
Yes, yes. No subsidy allowance was given by. And their own document shows, my lord, that no departmental proceeding initiated or even contemplated against me, my lord, in the document annexure and page 42. Your lordship other than various. No cases pending against.
What to do? No, pendency is not the issue.
Yes.
It's an interpretation of rule only. Interpretation of rule only.
Yes.
Where's this? Todi.
Oh,
Let go.
yes, sir.
Your lordship.
So sorry, came up so early. Yes. You will it.
Your Lordship,
Regarding rule 6.
yes, Your Lordship, on the last occasion, my colleague appeared. I heard the proceeding. Now, Your Lordship is basically with regard to that once the suspension has been revoked,
Yes.
whether any penalty can be imposed with regard to break in service. Your Lordship, my submission is this, Your Lordship. As regard the suspension, we have not taken any action. We have revoked the suspension and given him reinstatement. The question here is not about the suspension and the period, that prolonged period. The question is that whether he was attended the duties during that period.
No. That is,
Because, Your Lordship,
he has not attended, but then your rule 26 says.
no, the 26, we are not taking into account. Here is a case, Your Lordship, why rule 26 comes into place is that when a person is placed under suspension, he is expected to be there in duty. There is no break of service. He is not told that you sit at home. He is required to be continuously there. He may not have been given assigned a duty. Here is a case, therefore the rule 26 says that if you have attended and during that period, thereafter no penalty is imposed upon you, you get back everything because the suspension was not on account of his fault. Here is a situation where he was not even there in place. He was all along being absent 17 years, 17 years, 8 months. He didn't come to report for duties.
Let us see the rule 36.
Treatment of the period of suspension.
Where it is?
That is in the conduct, discipline and appeal rules.
Which rule you are relying on?
Conduct, discipline and appeal rule.
No. You are relying on rule 24(6).
26. 24 talk, 25 talks about subsistence allowance. That your lordship has, we have cleared on that he is not entitled for any subsistence allowance during that period because he has not attended.
Then come to rule 26.
When the employee under suspension is reinstated, the competent authority may grant to him the following pay and allowance for the period of suspension. If the employee is exonerated and not awarded any penalties mentioned in Rule 27, the full pay and allowance which he would have been entitled to if he has not been suspended, less the subsistence allowance already paid to him. Understood. But here is a case, my submission is that for this 26.1a to be applicable, he has to be there on duty. He has to be reported for duties. The principle of no work, no pay comes here. If he is not even there, this is a case where I understood if a person has been wrongly suspended and he is still there, once the suspension is revoked, you get back everything. Because the principle, like the Supreme Court says, that no pay, no work, no pay will not be applicable where it is not the fault of the person concerned, employee. The suspension being not of his fault, definitely he will get it back. But here is a situation where he has not even reported.
What have you done? Have you not done anything on this? There is two provisions. If the employee is exonerated and not awarded any of the penalties so and so, full pay and allowances which he would have been entitled if he had not been suspended.
Less the subsistence allowance already paid to him. Because
Not subsistence allowance has already been not paid.
subsistence allowance not been paid
If otherwise, as proportion of pay and allowances as the company.
as the computer. Your Lordship, what has happened? Your Lordship,
In
can I
case
just?
falling under subclause, the period of absence from duty will be treated as period spent on duty. In case falling under subclause, it will not be treated as period spent on duty unless the competent authority so direct. Yes, you'll have to treat it.
No,
Whatever maybe.
No,
he
it
has been
cannot be, Your Lordship.
reinstated.
I understood.
He's not asking for the period during this 17 years. He is asking for a period of suspension, which you ought to have invoked rules 26.
No. 17 years is the period when the suspension was on force. Your Lordship, the date, if I may just give it to you, Your Lordship.
What have you done about 17 years?
No, my lord,
Who, me? He didn't even come
No, not coming. What you have, no, you didn't pay any single penny.
because he didn't report. Then this rule comes into being. An employee under suspension shall be required to report in the office 24(6) note.
No, it's okay. It is requirement, but after the treatment of the period of suspension, what you have to do?
We have reinstated him and he's getting all his salary from that day when the date of
That's
reinstatement.
why I'm saying subsistence allowance is entitled. You see,
How, Your
in
Lordship?
case of falling under subclause, the period of absence from there will be treated as so and so.
Absolutely, I agree, but the person has to be there in that, during that period. How, Your Lordship is basically will be laying down an entitlement that a person who has not even reported for duty
That
is
is during
still,
the period of suspension. After the treatment, after the reinstatement, what you have to do? You have to invoke rule 26.
No, because your lordship, if your lordship may just see the facts. There was a case where his suspension was revoked way back in 2002, along with his acceptance of resignation. He challenged both the revocation of the suspension as well as the acceptance of resignation before this honorable court. This honorable court stayed the entire order. So his suspension also continued during that period. Wait till 2008. He never came to us to report for duties. 2009, once the judgment of the dishonorable court came, because this honorable court gave us this thing that no doubt we are setting aside the resignation, acceptance of resignation. However, the authorities will be entitled to reconsider whether he should be allowed to resume, join the duties or not. Because if a person is absent, as per the leave rules, unauthorizedly, it is deemed to have resigned. So this honorable court gave us that, and we on humanitarian grounds said, okay, we are not giving you that. We're taking you back, but since you have not served during that period, nor reported during that period, your period will be construed as an unauthorized. Suspension is in a different chapter, your lordship.
Oh, he's asking for, why not on that? Wrongly, rightly, whatever, the things, the position stands today, that you have reinstated it, whether humanitarian, whether penalty, whatever, you have to invoke Rule 26.
Now the situation, your lordship, he was
Where the
reinstated.
Last order of the court, where his suspension was.
Yes, that your lordship may see at page 45. The relevant paragraph is paragraph 13, page 55.
Yes, in the result, impute order dated issued by senior Sundoma in Sugar is released to the acceptance of resignation order with the defects and survey and approving person of the application by the concern must be the permission.
Page 55, 55, 56.
Yes, you have allowed it. Then where is the reinstatement order?
Page 57.
With reference to which is to inform you that the complaint authority allowed you to join in the association. What is KHEP?
Coming hydroelectric project.
In view of the unknown, subject to production of your medical fitness certificate. Then he joined.
Then he joined.
Hmm.
Then in 2009, he made a prayer for a year. 58, your lordship. If your lordship says,
Allowance, full pay and. other
directed to
consideration.
convey the decision of the government that the period of long gap of absence shall be treated as break in service and not unable to drop owing to not reporting during the period of suspension. We are not talking about
This is under challenge. This is under challenge.
this order is now challenged. We are treating his long absence, your lordship, not the question of suspension here.
Yes,
One thing, my lord.
not one thing. Let it
Very
be two,
important, my
three
lord.
things.
My lord pen says 17 years absent, my lord. That's not 17 years because in 2002 I approached the Honorable Guwahati. And finally we filed this writ challenging the order.
No, when the rule requires you to attend the office during the period of suspension, why have not attended?
No, my lord.
Have you attended?
No.
Did you
I
attend the office?
No, I did not.
Then,
No, my lord. Important thing, my lord. Once I approached in 2002 before the Honorable Guwahati High Court, my lord.
why you should be granted the subsistence allowance? Tell us.
Oh, yes, my lord. Because they did not take any, my lord, if, suppose, if I am absent from their office, is their duty to take action against me? No departmental proceeding initiated
No,
against
no.
me, my lord.
This, your
But-
requirement is during the period of suspension, you have to attend the office.
Yes.
That you have not done.
Not done, not done, because
So,
of,
And
because-
in the last order of this court, there is nothing on it.
no,
You have not asked for any subsistence allowance.
no, no,
You knew that you have not been paid.
yes,
You are supposed to get it.
yes, but from 2002
Peculiar
to
factor
2009, my lord, from
circumstances.
2002 to 2009 case
Why
was
you should
pending,
be
my lord.
granted? Tell us.
Because, my lord,
Why, how you are entitled? When the rule provides that you have to attend the office.
yes, I did not attend it. That does not mean that I will be disentitled, because, my lord, kindly say
And
26,
your
26.
all your suspension period is treated as a break-in service,
No, my lord.
not on duty.
No, break-in service, my lord, from 2002, my lord. My break-in service, they've done it in 2010, my lord. It should have been in 2002, my lord. Then, my lord, in that case, my lord, my salary for pension would have been counted from 2002, my lord, because I approached the honorable court. That aspect is also there, my lord.
Why
No,
not on the, now we're not on the
It's in
pension and
26.
other thing.
My lord,
You
kindly
have
see
retired from the service.
26(1)(b), my lord. Kindly see, my lord. I've already retired, my lord.
Ah.
Kindly see 26(b), my lord. This is very important, my lord. If the employee is exonerated, no question of exoneration, my lord, they did not proceed to the departmental inquiry against me.
You have not realized that, have you realized that in
no.
your pleadings? Have you
Yes,
said
yes,
anything?
yes,
on-
it is there, my lord. Kindly
Where,
see.
where? Oh, no, I've read it. Where is your pleading on that rule?
It is there, my lord. My lord, paragraph 17, my lord.
Read it.
Page 13, madam, that the NEPCO personal manual conduct discipline appeal rules 25, 24, 25, 26 deal with suspension. It has been provided in rule 24 that an employee under suspension required to report in the office of the security officer or in any other office as may be specified on each working day at the given time, failing which the subsistence allowance for the period is liable to be deducted from the payable allowance, which cannot be applicable in the instant case the petitioner was suffering from mental problem and submitted resignation, but same was not accepted for 10 years. Ultimately, when accepted in 2002, my lord, honorable court here initially stated the same and set aside and subsequently set aside. Hence, applying rule 24, the petitioner cannot be deprived of legitimate subsistence allowance. Then, my lord, further rule 25, it is my statement, paragraph number 18, has elaborately provided the procedure of an employee reinstated after suspension, which reads as follows. After suspension, I have been reinstated. Treatment of period of suspension. When the employee under suspension is reinstated, the competent authority may grant him the following pay and allowance for the period of suspension. If the employee is exonerated and not awarded any penalty under Rule 27, no question of, because no departmental proceeding initiated, no penalty does not arise by that. The full pay and allowance which would have been entitled to if he had not been suspended, less the subsistence allowance already paid to him. If otherwise, such a proportion of pension, proportion of pay and allowance as competent authority may prescribe. In case of falling under clause subclause A, the period of absence from duty will be treated as period spent on duty. In case falling subclause B, it will not be treated as period spent on duty unless the competent authority directs so. Yeah, in the case of the petitioner, fairly and squarely falls under Rule 26(1). This is my case, by 26(1), subclause A. Hence, he is entitled to benefit as provided therein. Moreover, respondents are guilty of depriving the petitioner of his benefit without conducting departmental proceeding. How my benefit can be deprived, my lord, without initiating any departmental proceeding, my lord? What action they have taken, my lord? Not even show cause not issued, my lord. His service has been tagged with break-in service and thereby depriving him not only unpaid subsistence allowance, but also continuity of his service, and it is its consequential benefits which are not sustainable in the eye of law. That's my case. What action they have taken to deprive him? This is my case, my lord.
How you were suspended? What is the allegation?
Well, initially I was suspended when I I was arrested in a police case, my lord. And that case in 2093 itself, my lord, I have been acquitted. In fact, I have been immediately
2000?
put on suspension in 2093, my lord. Your lord kindly see, my lord. Page 42. Election and my lord.
26, 91.
Yes, yes. 26.
Arrested and you're arrested
Yes, yes, yes.
and granted bail.
Yes, yes.
When? After how many days?
After 24 hours, of course, my lord. My lord, it is there. I have made a statement, my lord.
Not 24, 48 hours.
Yes,
I
yes.
think.
48 hours.
48 hours, yes. 48 hours.
Paragraph 6.
Yes, paragraph 6 it is there, my lord. Yes. Paragraph 6, page 5, my lord. On getting information of WT message 31/5/91 issued by so-and-so, about the need of petitioner reporting the senior personal officer, then he went to Doyang and so-and-so. When he learned a police case was registered against him, the said case was registered on the basis of a written complaint made by then security officer in respect of the theft of fencing. The petitioner was kept in custody for more than 48 hours on 26/91 in connection with the investigation of the criminal case. He was also present both mentally and physically. All these incidents have been duly intimated, my lord, at that time. My lord. But that case has ended in final report and accordingly he has been acquitted, my lord. And no case is there. Then he submitted joining report. My joining was not allowed, then I submitted my resignation, my lord. My paragraph number 7, may I read, is important, man. I was also initially not intimidated about my suspension. Well, paragraph number 7, my lord, very important, my lord. May I read, my lord?
What?
Well, it indicates, my lord, when I went to join, my lord, after I released from the police station, my lord, I came to join. I was not allowed to join, not because of my suspension. I was not allowed to join because my application was not supported by any
No, we're
medical.
not concerned about
Ah.
that. We're concerned about the suspension.
Yes, yes.
Here,
Then-
where last occasion we said, other day we said nothing.
Yes.
Only subsistence allowance.
Yes, yes, yes.
Yes. That's all.
That's all. The rest I.
And Mr. S. Islam.
No, my lord, A. Chaudhary.
Huh?
A. Chaudhary.
A. Chaudhary.
Madam.
A. Chaudhary, learned counsel for the petitioner. And also heard Mr. D. Senapati, learned counsel for the
Even?
standing counsel.
No. 228. Council for
D. Senapati. For learned counsel for NIPCO.
NIPCO. Respondent number 228.
Respondent number 228. Who is for one? Nobody. And
Union
right,
is,
and
union is an.
then you write and heard MS G Gan, A Gan, learned CGC for respondent number 1 and Miss D. Senapati learned counsel. D. Senapati and S. Todi, MS S. Todi for learned counsels for respond 2 to 8. 2 to 8.
228.
So you are challenging the order 604/2010,
Yes,
where it said that your long gap of absence of petitioner treated as a break-in service.
yes, my lord, that part is also there. So because of this, everything gone, my lord. That was also done without any notice, my lord, on my application that replied break-in service. It has to be done, by your chauffeur. That's my submission, humble submission.
The challenge made in this petition is to the communication dated 06/04/2010 issued by the Deputy Manager PNA Cricket Cross established Lepco Limited, Slough. Where it is? Page number?
58.
PNA established ESSP dot Lepco Limited, Slough. Whereby the decision has been conveyed that the period of long gap of absence is treated as break-in service and not enabled to withdraw subsistence allowance owing to not reporting during the period of suspension. Next, briefly put, the case of the petition is that he was appointed as junior engineer within bracket civil grade 2 of the Northeastern Electric Power Corporation within bracket NEPCO in short bracket close. By an order dated 8/4/2000, 8/4/1988, and joined his service at Doyang Hydroelectric Project, Walker, Nagaland, on 27/04/1988. The petitioner was posted as junior engineer, grade 1, on in-charge basis at Kopili Hydroelectric Project, Umrangso, by the order dated 14/03/1999, on his own request, wherein he joined his service on 25/04/1999. On 05/06/1991, the petitioner came to know that a police case has been registered against him. On the basis of the written report of the written complaint made by the security officer from DHEP in respect of theft of fencing post, and the petitioner was arrested and put behind bar for more than 48 hours on 20/06/1991. The petitioner they submitted a representation on 06/07/1991. Before the responding who stating, no, narrating his bad experience of Joanne. However, the petition was put under suspension from with effect from 26/06/1991 by the order dated 10/11/1991. 11/10/1991. Next. The petition again submitted a representation by the adjourning report on 11/10/1991. Stating that he did not join earlier because of intensive medical treatment he had to undergo starting from 26/06/1991 in connection with the torture which have been subjected to by senior security officer and the police before handing him over to before handing him over to police in connection with the criminal approximate criminal case. However, the same was returned for want of necessary medical fitness certificate. Next pair. The petitioner on 01/01/1992 submitted a representation tendering his resignation from his service, stating about his sufferance and unwillingness to work for the proposed network any further threat to allow to get all his dues and entertainment. Thereafter, a reminder was submitted with regard to his prayer for resignation on 12/02/1991. Next parent. In the meantime, the criminal case being woke up ES case number 4/1991 under section 380 IPC corresponding to GR case number 34/91 against the petitioner was closed on the ground of insufficiency of evidence as against him on 22/07/1993 by the London SDA subdivision magistrate, Walker. Next period. Thereafter, on 17/04/2001, the petitioner submitted an application seeking withdrawal of the resignation letter, which he had submitted on 01/01/1992. Containing that its acceptance before its acceptance by the competent authority. Thereafter, he submitted joining report on 18/04/2001, which were forwarded to the competent authority. Next time. On 27/02/2002. Order was issued stating that is issued by the respondent authority to the effect that consequent upon disposal of the criminal case against the petitioner, the competent authority had accorded approval towards the acceptance of resignation of the petitioner with effect from 01/01/1992. And the suspension of the case against the petitioner was and revoking and the suspension of the was revoked. Next one. Being agreed, the petitioner approached this court by filing the WPC. Approached this court being WPC 4919 of 2002, challenging the acceptance of resignation. And challenging the suspension not allowing him to join in his service, as well as the resignation of the acceptance of resignation of the petitioner after 10 years of submission of prayer position, resignation. Contending that the same has been accepted without considering the withdrawal of the prayer for resignation before the sentence. This court, after consideration of all the considering the matter by the order dated 15/02/2008, allowed the writ petition by setting aside the order of acceptance of resignation dated 27/02/2002, issued by respondents. Over. has been observed that an appropriate consequential order had to be issued by concerned authorities in some response in respect of the service of the petitioner in accordance with law. The question cannot, the petitioner is or not to be allowed to join in his service will have to be decided by the school authorities in accordance with law and having regard to the actions of mentioned in the report. There is no separate order of reinstatement.
Separate. Page 57 is the order of reinstatement.
It's not order, it's a communication allowing you to join.
There's no separate, this is the only order.
There must be some proceedings, I mean, some decision, approval, something like that.
I don't have the record.
No order has been issued. It's and you are allowed to join, joining in the.
This is just joining.
Thereafter, the responding authorities to the senior manager within the P and A bracket clause by communication dated 1303
13-3.
2009.
Pilot.
Issue. The allow the intimated the petitioner to join in his service, stating that the competent authority has allowed him to join in the substantive post of KHEP, Petitioner, page 57. In view of the order of the High Court, subject to production of medical fitness certificate within 15 days. Then when did you join?
Yes.
You joined?
Yes, I joined.
Huh?
Yes, I joined.
When? Where is the joining report on the all? The petitioner. Come up accordingly. Join his service. When did he join?
He joined on 29/4/2009.
29/4.
4/2009. Statement is there.
Also,
Paragraph
you have
30.
not joined within 3 days, with 15 days. Anyway, there is no dispute.
Yes, sir.
There is no dispute to that.
I've stayed long.
When?
Yes, there is on
29/4,
4/2009.
24,
Yes, a statement is there, paragraph number 30.
29/4.
4/2009.
Statement 8 para. 29/4/2009
Paragraph number 13, it is there.
on having been on reinstatement. Please stop it. Then you file an application.
Yes.
When? For subsistence allowance.
Yes, my lord. I filed application, my lord, on
8 October 2009. That
Where
8
where it is?
page 58, it's referred to.
No, this application I wanted to know. Where is the application?
Application is not.
I'm not an expert. Quite voluminous, all those documents were there.
What voluminous? No, at least you must have the application.
Yes, yes. Application, we paid this thing, my lord.
Next para. It is contended that thereafter the petitioner has filed an application for release of subsistence allowance, pool pay and other consequential service benefits. And the period of subsistence from duty be treated as period spent on duty. Next para. And please, no, not next para. By communication dated 06/04/2010. The deputy manager, within bracket P and A, bracket close ESST, this is page 15. The claim of the petitioner has been rejected. the claim of the rejection of the claim of the petitioner is conveyed by which, claim of the petitioner is is conveyed. The rejection of the claim of the petitioner is conveyed. Stating that the decision of the stating that the period of long gap of absence shall be treated as break in service and not unable to draw substantive allowance owing to not reporting during the period of suspension. As this writ petition essentially seeking for payment of substantive allowance during the period of suspension. When he was suspended in 1992,
91.
91 to reinstated in
He was reinstated in 2002. His suspension was revoked with the acceptance of the resignation, 2002. That was stayed by this honorable court. So both got stayed. Therefore, the suspension again became revived.
I'm not going to. Then revoked, it was revoked in
2002.
1991 to 2002, how
Two.
many years?
91, 9 years. Mana?
For the period, for the suspension period, i.e. 1990, you give that 1990, so and so 1990.
10, 11,
1
12.
to, which date revoked?
Revoke is
27 to 2002
27.
to 2002 by the next.
Well, you have been allowed to directed to join
no.
before that. Where it is? Where it is?
Well,
That order is, your lordship will find
That is
page,
57. I was
no,
allowed
no,
to
no,
join.
no. Page 42.
Oh, that is there 42. It was revoked into 2002, my lord.
That is what I am asking, sir.
Yes, my lord, that is 2002. Annexure N, my lord, page 42.
He prayed for
702 2002, huh?
he prayed for subsistence allowance in the earlier writ petition also. That was there. If your lordship may see para writ petition for nothing.
But that is not been dealt into by the court.
That has not been considered or and not considered would be correct. Any prayer made is deemed to have been considered.
Where it is?
That your lordship he has not annexed. Page which one? Writ petition condition. I have a copy. Direct the petitioner to allow the petitioner to join in his post and further direct the payment to pay his monthly salary since November and after hearing. From November 91, he was asked 4912.
4919 2002.
Where do you get that? Next,
20, page number 20.
Mr. A. Chaudhary, learned counsel for the petitioner. By referring to the provisions of, what is this provision?
That's 26. 12.
Huh?
Rule 26.
Conduct, discipline and appeal rules.
No, this page is 5, 6.
NAPCO,
The
paragraph number 17.
NIPCO conduct, discipline and appeal rules.
NAPCO personal matter conduct, discipline and appeal rules. Paragraph number 17, my lord, page 13.
Submits that. Particularly Rule 26
26, page 24. I have
submits that. Since there.
Whether
particular rule 24, 25, and 26 submits that the rule 24 would not apply to the petitioner as the petitioner was, which deals with the suspension and the treatment of the period of suspension. Submits that the rule 24 would not apply to the petitioner as the petitioner was suffering from mental problem and had submitted resignation letter and which was not accepted for nearly 10 years. Although it was, no. He submits that since the petitioner has been exonerated from the criminal case, the full payment exonerated from the criminal case, and there be there and there be no deferment proceeding initiated against the petitioner. The full pay and allowances from 1991 to 2002 also have been really granted to the petitioner. Mr. Therefore, he submits that the respondent authorities may be directed to grant the subsistence allowance from for the period of suspension, i.e. 1977, 91 to 2007, 27 to 2002. Listen, next way. Mr. D. Senapati, Land Council for respondent with 8. Referring to the provision of Rule 24. Of the conduct and application. Semester. The petitioner had never attended the office even for once during the period of suspension. Rather, during the subsistence of suspension period, suspension order, he submitted the resignation letter, which was ultimately accepted. Although subsequently the said acceptance letter has been set aside, it was by the court. Mr. Therefore, an employee, the rule requires that the suspended employee shall not leave the station without the written permission of the corporation. And it clearly provides in the note that an employee under suspension shall be required to report in the office of the security officer or any other officer that may be speaking on each working day at the given time. In case an employee under suspension does not report in the office as mentioned above, the subsistence allowance for such periods is liable to be deducted from the subsistence allowance so payable. He further submits that the rule provisions of Rule 25 and 26 would not come into play as the petitioner has failed to report and has failed to report to the concerned authority during the suspension period, during his suspension period. Rather, he has left he left and abandoned his service. Therefore, the petitioner is not entitled to the subsistence allowance. With such the respondent authorities has rightly rejected his claim, treating the suspension period as not spent on duty. That is what your submission.
That
Who 25 and 26 will not come.
would not apply
Yes.
because it was all.
Due consideration has been extended to the rival submissions and valid functional of the parties and also there is the materials available on the court. Next one. The petitioner was put on the suspension, so and so, so and so. And his case was revoked after the closure of the criminal case.
Subsequently, when he submitted, in the meantime, 91 he was suspended, 92 he gave the resignation. Then he disappeared. 2001 he appeared, wanted to join. Then we accepted his resignation.
After the suspension, in the year 1993, which in particular there,
In when he submitted the
Yeah, yes.
resignation,
yes. 19 so and so there, 1993.
1991,
19
two.
Immediately after the suspension,
Yes,
90 suspension is 1991.
one.
And
1/1/92, he submitted his resignation.
1/1/1992.
Huh?
1/1/1992, I submitted my resignation.
Before suspension,
Suspension, it was 10/11/92, 91,
11/10/1991.
1.
Okay. 19 suspended so and so, 11/10/1991. Thereafter the
1/1/1992 submitted
petitioner
resignation.
submitted as resignation. Submitted an application for praying for resignation from the service on 1/1/1992.
Yes.
Then when he resurfaced,
2001. He had said severe, he was not about the happening from 92 to 2001. That, and then he submitted his application on
Thereafter-
17/4/2001.
thereafter and thereafter, after the long lapse of
9 years.
9 years, nearly 9 years, the petitioner, long years of 9 years, submitted a joining report,
Withdrawal of
resignation.
withdrawal of, seeking, submitted an application seeking withdrawal of his resignation letter submitted in the year 1992. Then
2001.
2001.
One.
In the year 2000.
Re-
Which date of that
Application
application?
17/4/2001.
9 years, Then,
18/4, I had submitted application for joining my. On 18/4, next date, I submitted application for joining.
And then 20,
and also submitted his joining report
Yes,
on the
18/4,
next day.
yes.
then we passed the order on 27/2/2002, accepting his resignation,
2002.
which was challenged in the writ petition.
Admittedly, before the acceptance, he has.
he
submitted
has
his
communicated the withdrawal.
The respondent authorities accepted the resignation of the petitioner by an order dated
27/2/2002.
22, which is after the
Withdrawal of,
withdraw application for withdrawal of the resignation of the petition. After the submission of withdrawal of submission of application for withdrawal of
Resignation.
resignation application. Mr. This court has set aside as noted about this court has set aside the exceptions of resignation dated 27/02/2002. This was thereafter the petitioner upon exoneration of in the criminal case upon closure of the case due to want of sufficiency of evidence among the respondent authorities has revoked the suspension order on
27/2/2002.
same day, right?
Yes, we revoked and we accepted the resignation.
Same order.
The suspension of the petition was revoked on the same day, i.e. 27/2/2002, when thereafter the acceptance, the order of the resignation of the petitioner is accepted. Accordingly, the petitioner has been allowed to join. And reinstatement, according to petition, was reinstated and allowed to join the service. Like communication dated
13/3/2009.
2009. The petitioner, the respondents rejected the claim of the petitioner with regard to full payment as well as other entitlements during the suspension period, treating the period of suspension to be not spent on duty, right? Not spent on duty. Mr. Lee. On consideration of the matter, it is noticed that the issue to be determined in the present case as to whether the petitioner will be entitled for a subsistence allowance under the rules, that is NEPCO conduct discipline and appeal rules. Next. To appreciate the relevant rules, the rules are referred and considered, which are referred to here in below. Rule 25, 25 and 26. Next, perusal of the above provisions shows that suspension is regulated under Rule 24, wherein it is required that the suspended employee shall not leave the station without written permission in the corporation with an not attached to the effect that an employee under suspension shall be required to report in the office of the security officer on each working day and be given their work. And in case an employee under suspension does not report in the office, the subsistence allowance for such period is liable to be deducted from the subsistence allowance. So payable. Rule 25 indicates reflects the subsistence allowance which provides subsistence allowance with the effect that the employee under suspension shall be entitled to subsistence allowance equal to 50% of his basic pay, provided the dispute authority is satisfied that the employee is not engaged in any other employment. Said to me. Rule 26 shows that the Rule 26 provides that it provides for the treatment of the period of suspension, which states that the employee under suspension is reinstated. When the employee under suspension is reinstated, the competent authority may grant full and pay and may grant pay and allowances for the period of suspension. If the employee is exonerated and is not awarded any penalties mentioned in Rule 27. In 27, the full pay and allowances which would have been entitled to if he had not been suspended, less the subsistence allowance that he paid to him. In case the employees exonerated paid full pay and allowances, the period of absence from duty will be treated as a period spent on duty. Is noted that the petitioner has not only attended the office, but appears to have abandoned his service for long period of 9 years after submission of his resignation letter. And appears to have resurfaced only after a lapse of 9 years in 2002, when he, by filing a petition seeking withdrawal of his resignation application. It is admitted position that the criminal case against the petitioner, which was the basis of wherein he was arrested, the basis of suspension has been proved due to insufficiency of evidence by the concerned form. Thereafter, the petition has been reinstated, and thereafter the suspension of the petition was revoked and accepted the resignation. However, this court has set aside the acceptance of the resignation petition. Consequently, which the petitioner had reinstated allowed to join in his service. On careful reading of the Rule 26, it is noticed that when the employee and the suspension is reinstated, the authority has to authority will grant him full pay and allowances if the employee is exonerated and not awarded any of the penalties provided under Rule 27. And if the employee and the authority granted pay and allowances, the period of suspension will be treated as spent on duty. They know attached to the attached to Rule 24 provides that an employee under suspension shall be required to report in the office. And in case of failure, the subsistence allowance for such period is liable to be deducted from the subsistence allowance so paid. The admitted position is that the petitioner has not reported to the office even for a month during the suspension period. Till he submits his resignation, submits his application for withdrawal of, seeking withdrawal of the resignation application. On 27/02, when he did submit
When did it?
submitted his withdrawal,
Withdrawal was 27 to,
same day,
no. Withdrawal from
you just
27 to 2002. No.
before that,
17/4/2001.
17/4/2001. Having considered the provisions herein above, since the criminal case of like proceedings against the petitioner, the basis on which the petitioner put under suspension, the petitioner was suspended. The responsible authorities ought to have resorted to Rule 26 of the so and so rules, It was because the material reveals that the said provision of Rule 26 don't be so 90, except a decision to treat the suspension period of the petitioner as not to be as it not spent on duty. It is equally to the it is equally admitted that the petitioner has not reported or attended the office even for once during the suspension period. In that event, if the petitioner has not attended the office, or attended the office or report to the office, or attended or report to the office, as per the note cast, the subsistence allowance for such period or to have been deducted from the subsistence allowance so paid. Mr. Merely because the petitioner has not attended the reporting to the office as required under Rule 27. The period of suspension. The petition, the entitlement of subsistence allowance cannot be totally denied. Is clearly provides for deduction of the subsistence allowance paid in more than full subsistence allowance. The petitioner was noted for provided with subsistence allowance. Due to the reason that the petitioner has failed to attend or report to the office. This is what I'm doing. On consideration of the intent of the rule 6 is noted here in my considered opinion, the respondent authorities ought to have resorted to the said rule. Is admittedly, no, is due to, no, upon closure of the criminal case of the proceedings, against the petition, it may be treated as an exoneration from the said case. And admittedly, the petition having been reinstated. The resort to such rule was is inevitable. So then get it in. I'll apply my mind.
Well,
I didn't,
Finally, I'll apply my mind. But as of now, Rule 626 ought to have been invoked. It's not complete
Alright.
denial, not, it's only deduction. All right.
no deduction, provided you are
Okay,
entitled
I've
for.
heard you and I've decided. I'll just apply my mind and.
Only one thing.
You'll get the result.
No, yeah, absolutely, Your Lordship. Only one thing, Your Lordship, one of my submission was also no work, no pay. That Your Lordship may
No, that's
consider.
not relevant.
Yes,
Substances allows no relevancy. Purely it will be regulated by your conduct rules. Section 24, 25, 26.
no, it's a full pay.
Problem is, he has not reported, he has been for long years, in fact, he has abandoned, that's why,
That's
that's the reason. he may-
otherwise, though, he would have got it
Ah.
anyway.
That's the reason he may not. But let me see, this was out.
this problem.
Here. Yes,
He at this 2001 to 2002, he can still, since he has come back.
if you are giving that concession, that can I also record.
2001 to 2002. when he applied that 17/4/2001, he sought for withdrawal.
From
2002,
there onwards.
if he is considered to be in suspension that he has reported, At
2000
least we can-
how many months there is?
that will be
9 years.
4 to 8, 6 plus 2, 8 months.
8 months. Are you happy?
I leave it to lordship, my lord. Sir, joined in 2009, up to 2009, I
record
can
that.
reconsider.
At best, if this court, I'll record your submission at best. If this court finds that he is entitled, would be for the period from the date of
17/4/2001.
submission of his withdrawal of seeking withdrawal of the resignation letter
Till
till
the date of revocation of the
yes, 27/3. I mean 27.
7/2/2002.
2, yes. Okay,
My lord.
I'll
Oh, my lord.
consider. Twenty-four.
Lordship, I have found one judgment, Lordship, of July 2024, Lordship,
Yes.
where the citation that has been relied on by the petitioner's counsel, Lordship.
Yes.
Similar things has been discussed, Lordship. This is Union of India and others versus Shishupal LS Shipal. This is of July 2024 judgment
Yes.
of the Honorable Supreme Court, Lordship. And I rely on the paras 21, 23, 24.
21.
Yes, 21, Lordship. Here, ultimately, the purpose of seeking the relevant information with respect to the antecedents of a candidate employee is to enable the employer to ascertain the suitability of a candidate employee for the subject post, Lordship. This is there. Then 23 here, there also, Lordship, the state of Madhya Pradesh, Bhupendra Jadhav, then Avtar Singh case has been discussed, Lordship. In para 23, in Rajasthan Rajya Vidyut Parishad Nigam Limited and another versus Anil Kanoria, this court had opined that even where there was a subsequent acquittal, an employee cannot claim appointment as a matter of right, having furnished false information or having indulged in suppression of material facts relating to a pending criminal case. This is there. And here the case, this is which has been decided in this petition, Lordship. This in the para 24. In the case at hand, the learned, the single judge has erred in accepting the submission made on behalf of the respondent that it was only after the appellants passed the order dated so and so, removing him from service, that he had inquired about the criminal case pending against him, and later on the respondent was acquitted in criminal case so and so. As noted above, the said observation ran contrary to the record itself that clearly reveals that the respondent was well aware of the fact that a criminal case had been registered against him. He was taken into judicial custody and subsequently applied for a bail along with the other co-accused of the said case. Lordship, as granted by a trial court on 4th October 2011, all the aforesaid events had occurred well before 30th November 2011, the date when the respondent had filled up the verification role. Therefore, it has to be observed that the respondent had complete knowledge of the registration of the FIR and pendency of the criminal cases. And despite that, he had willfully withheld material information from the appellants while filling up the verification role.
The problem is, this was a case relates to a dispute between
Lordship.
family members against him. Of
Elder
course,
matter.
there's no dispute that he has suppressed.
Yes.
He has not.
Yes.
He has not affidavit, he has not said it is no dispute. But case was, relates to, you are not arrested,
No, Lordship.
relates to a complaint filed by his
For elder matter.
elder matter. On the
Understood,
basis,
Okay,
due
Lordship.
to family disputes, property disputes.
Yes.
No, whatever it be, Lordship, but he had the knowledge on that date
Yes.
when he submitted the affidavit that no case is pending against him. So he could have, that means disclosed these things, Lordship. This is there because this is,
And Mr. So-and-so, learned counsel for the petitioner and MS
M. Bhattacharjee,
M.
Lordship.
Bhattacharjee, learned state counsel for response. Heart in part list after 4 weeks.
Deeply obliged.
Let me go through all this. You also go through, give him the
Your lordship,
copy.
Lordship.
We are not denying that we have not held that affidavit.
No, no, you see the latest judgment of Supreme Court.
Yes, Lord.
There is 3-4 cases has been started. All right,
Lord, this part has not.
well, and half part of.
Lord.
We'll
Deeply
keep it
obliged,
further.
lordship. Lordship, my name may kindly be shown in the cause. I may miss lordship, that's why.
MS, the registry to reflect the name of London State Council, Mr. MS M. Bhattacharya. Bhattacharya or Bhattacharya?
Bhattacharya,
Charya.
additional
Why,
senior
why
J.
and G, JI?
JEE.
What is the difference?
Nothing difference,
Not
lordship,
brother-
the way of writing.
Brothers and sisters.
Yeah, lordship.
Huh? Bhattacharya and Bhattacharya not brothers and sisters. Huh? Not. It's not. You are not brother, you are not family, I mean, related.
And not that lordship. This is the way of writing lordship. My father has written like JEE, so I have written, but my son, he writes YA. So it's up to one.
No, no,
lordship.
it's one and the same. Brothers only.
Yes.
Okay. Why I'm asking because now try it. Mine is Ete, he is a Asi. He's
Yes.
like my brother only. It's like my cousin.
Yes, yes, there are,
That's why I'm asking.
yes.
Bhattacharya and Bhattacharya.
It's after 2 weeks, Lord. 2 weeks. After 2 weeks. Lord.
4 weeks. This court will sit after maybe 6 weeks or 7 weeks.
Lord.
Deeply obliged,
Alright.
lordship.
You share a copy of this judgment.
lordship. I'll give it to you.
Let us learn together. Yes. Sunil Kumar Mishra.
May I please, my lord?
Yes.
My lord, standing counsel, Mr. B. Chaudhary is appearing for this matter. As of now, he's on legs in another court, my lord.
So what is to be done?
Time being, my lord.
Huh?
If my lord pleases, my lord.
Lord, I am a bit unwell. I was hospitalized also. That
You are also not unwell.
yeah, unwell.
You are also unwell.
Yes, unwell.
Not unwell or unwell.
I am still unwell.
Release
I have
from
to
the part heart. Because this court may not is away for 4 or 5 weeks. So release from the part heart. The Mr. Your name, please?
R. Sharma.
R. Sharma. Learned, Dr. R. Sharma. Learned
Mr. R.
Constable.
Sharma.
Huh?
It's a mistake given.
Okay.
Mr. R.
Mr. R. Sharma, learned Constable Petitioner. Submits that he's not well with his health, therefore, praise for adjournment of the matter. Although this, although this matter was part in heart due to, I mean, since this court will not be able to take up the matter. A few weeks, let this matter be released from part heart. This after 3 weeks, 2 weeks, 2 weeks, I'm releasing it.
Yes.
Unnecessary keeping it. Mr. Sun.
Apply.
I thought we'll dispose of these part heart matters. Yes. Whatever. This also released, right? This also released. 12.
I'm for the petitioner and seeking a little accommodation. I have not been able to contact the client. So
This 2012 matter.
2012, matter, in between it came up a lot many times before this honorable court, and some money was also released to him under orders of this honorable court.
No further adjournment.
But that is there, but I have not been able to contact the client. I do not know if I need to even substitute
What
him.
is to be done?
First,
According
we
to
will
what
have it
you
next
say,
week,
what
my
do what do you think?
My
It
lord.
is still survive? Is
He
there any
survives.
solution?
He had challenged his compulsory retirement. In case he wins the case, my lord, then the issue will be of the
Sir, Majid,
interim period.
sir, problem is 2012 method.
I understand. Lordship will have it on Thursday, my lord. let me send someone to his known address, my
although
lord, just to
this
find
matter-
out.
Although this matter is not, what is not as a last opportunity. Today, since Mr. Majumdar, in view of the submission by in view of the submission of Mr. Majumdar, then counsel for the petition that he could not contact the petitioner, which would be necessary, which is necessary for argument, hearing of the matter. Let this matter be listed after a week.
Madam.
After a
I
week.
just try to contact him one.
Again, so and so. Let me see this is. What is this, sir?
Lordship, this order against the Sahara,
Huh?
that
2000 for the in process.
it has
Nothing
become,
much.
I don't think any company such Sahara exists today.
Huh? What is to be done in that case?
It
What
becomes-
is the prayer here? You are
So
for,
there was a preliminary this thing findings given by
you
the
are
learned.
for, you are for?
I am for this workman,
Huh?
workman.
Okay. The respondent, the learned lawyer.
Preliminary issue was framed wherein the court, reference court held that yes, inquiry was not duly conducted.
So, merit, there is anything,
I know there is no merit in the case.
non-appears for the petitioner on call, Mr.
BK Bhagavati,
PK Bhagavati, learned counsel for the respondents.
respondent, sole
All-
respondent, sole respondent.
So, respondent is present. Considering that the petitioner is Sahara, India. What is there? Is it still there or what? Sahara, India.
Sahara, I don't think, because Honorable Apex Court held,
Because there's much water have already flown, right?
Lordship.
Sahara, India. Journal Office, Rajgarh Road, Bangladesh. Yeah, considering that the existence of the petitioner appears to be doubtful and the known is, and also that nobody is representing the petitioner. Which will be dismissed for non-pollution. As well as the matter is pending since 2014, right? 2014.
13 matter.
Yes. This is one objective of the State of Assam, Chief Secretary, Government of Assam, Cooperation.
Corporation Department, Lordship.
So what is
Standing
this?
council is there, Lordship, for that department.
Huh?
Standing council is there. Lordship.
Yes, who is? Is for hearing. Call them. not appears for the parties. You are also not appearing.
I'm not a party.
Uh,
Lordship. Last
matter-
date also none
Matter
appeared, Lordship.
pertains to. No. A writ petition has been filed seeking a direction to the respondent authorities not to fill up the post of technical assistant by direct recruitment as per the advertisement dated 03/11/2012, that paying the salary of the employees of the corporation in revised pay scale. And as per the terms and conditions, the memorandum of understanding dated 02/05/2003. Considering above. Having considered above, it appears that this it appears that no live issues remains to be executed, and therefore the petitioner the parties have not, the parties are not represented. Then they are not interested to pursue the matter. Dismissed. Accordingly, this requisition dismissed for non-resolution.
Here, petitioner, in fact, petitioner, who was employed, appointed as the CRPF constable, was terminated, and after filing of this petition, he committed suicide. So, now, father implemented himself as a petitioner, facts of the case is that, after joining, while he was on training,
What benefit can be
benefit now if some because father is old ailing the only son
Suppose
was
if your
the
writ petition is allowed.
If
If
Yeah.
your writ petition is, what can be, what benefit?
yes, if
You would be
petition is succeeds, then some monetary benefits, pecuniary benefits or other maybe granted to the father because he is the only the source of income. He was the only earning member of the family.
Very down.
Very bad. Unfortunate. While son was undergoing training, then he developed some illness. And he was admitted in the departmental hospital. But for 3-4 days, nothing can be diagnosed. Then he came to Guwahati from Gujarat. He came to Guwahati and admitted in the neurological hospital and diagnosed with a brain tumor. Then the tumor was operated, and thereafter again his some defects in operation or something. He developed some eyesight problem, so he could not join at the time. And everything were communicated to the departments with medical documents, and they admitted also in their affidavit that his illness and was duly communicated to the department. But ultimately, he was terminated from the service, declaring him as a deserter. So, that is the grievance of the petitioner. So, our High Court already there are judgments, squarely covered similar situation. One
Give it to her.
yes,
What do you say?
he was also exactly similar. CRPF constable.
Let her go through it, similar method, why to understand it. Maybe similar, CRPF.
Exactly
maybe
similar.
CRPF,
Yes,
grounds,
exactly similar.
impugn
Squarely
order.
covered.
Huh?
Squarely covered, my lord. This petitioner also, while he was in training, he developed some illness. He came back and he was declared deserter.
And Mr. So-and-so, learned counsel for the petitioner submits that the present matter is, no, the case, what is the name of that?
My lord, case name is the,
order, judgment and order of this court.
yes, my lord.
Huh?
Yes, reported in, my
In the
lord.
case of,
Reported in,
judgment in the case of name of the case.
name of the party is, my
The
lord,
party.
Constable Pinku Kumar Pal.
Kinshuk Pal
Pinku
versus
Kumar
the
Pal.
Union of India.
Yes,
Reported in
2012,
2012,
5 GLR,
5 GLR,
860 page.
860,
60.
60 squarely covers the case of the petitioner hearing. List of MS. Again, London CGC press for some time to go through the same.
My lord.
Mr. Praise a lot. List after a week
Yes,
or
sir.
two.
Lordship may keep it as part heard or on next Thursday, my lord.
No, next Thursday, you'll have to come to Eternal.
Then, my lord, as your lordship available.
Next week. I'll not make it.
My problem.
My lord. Lordship has keep it as part heard.
No. It will be rather I'm releasing the part hard.
My lord.
Lordship may pass over this matter. Mr. R. Mazumdar is on like under.
What is the matter? Who is it? Yeah, madam, what is the matter?
Well, let's second.
Sorry, yeah. Heard Ms. So-and-so, Mr. So-and-so, learned counsel for the petition. On the prayer of MS G. Gyan, learned counsel for the petitioner, learned CGC, that she has inadvertently, she could not locate this, no, the ground this, since she has not been to locate the brief, locate the brief. A 2 weeks time will be there. The matter may be listed out. Very good. What I said, on the prayer, no. You said MSA again, one is CGC. That means that she has, she could not locate her brief, for which she faced for adjournment. After 2 weeks.
Yes, ma'am.
Obliged.
Yes, by looking at this hearing matter, you will be
Yes, ma'am. Next week.
unnecessary,
Yes, ma'am.
you'll take time, you'll ask for a time.
Must have
It's not a motion that you just go through. and-
Yes, ma'am.
Yes.
May it be the lordship.
Yes.
Lordship in this matter, although we were led by Mr. P. Nair,
Hmm.
however, Lordship, the learned advocate general expresses willingness to Lordship apprise in this matter, but because of the seriousness of the issue, but Lordship, he is on legs, Lordship, and that matter will continue in the second half also, Lordship, in court 10. Lordship, I pray that if your Lordship can accommodate and fix this matter tomorrow, Lordship.
Tomorrow is the last day. Already list are out. This code is, I had to go around 2 o'clock.
So far as your lordship, my part is concerned.
Not to enjoy weekend, but to attend the, administrative meetings at Eternal.
Lords.
Don't think that I'm rushing, this code is rushing
Lords.
to enjoy the weekend.
No, your lords.
I don't want to also rush.
Lords.
That meeting is fixed on 7,
Lords.
10:30, so I'll have to go. So tomorrow is not possible. So we'll keep it part hard,
Lords.
as and when this court.
Lords.
Her so and so, all of them, but whoever is it. In fact, we have.
Your
we have
lordship has
the
heard
petitioner.
other petitioner side, your lordship, only your lordship. I have some, so far as my matter is concerned, that is to be submitted, your lordship may hear it on next day.
What is the, how long you'll take?
Not, I will not take much time, your
You argue your part. also.
lordship.
Item,
Item number, your lordship may take it up, item number.
we'll keep it part hard,
Lordship.
and then when this court, we'll
Lord,
list after.
Their reply may be your lordship.
Lordship.
Item your lordship may kindly take up, item number 35.
35.
So far as
35.
item number 24 is
Or item
concerned,
number
my
35.
junior colleague has argued already, your lordship.
35. Yes,
Your lordship will find, your lordship here, your lordship. The nature of appointments, your lordship, these appointments were made at your lordship, different regional offices, your lordship of the ASTC. your lordship.
you are,
I am your lordship, here your lordship, WBC 4259, your lordship,
yes,
for 50 petitioners.
which grade?
Your lordship, these petitioners are your lordship, all your lordship mechanics, your lordship,
Mechanic,
mechanics, your lordship.
okay. Any notice of appointment?
Yes, your lordship, I will show that, your lordship. Before that, your lordship will kindly come to page 38.
Hmm,
of the
admission
petition.
notice.
Lordship, that is your lordship, these petitioners, your lordship, they
Are
were
the ITI?
ITI, your lordship, run by the your lordship ASTC itself, your lordship.
Huh?
ASTC itself, Assam
Assam
State
State
Transport Corporation. your
Corporation,
lordship.
the respondents here is.
Yes, your lordship, they are the your lordship authority who appointed us.
Mechanic.
And they, your lordship, in fact, your lordship, run an ITI, your lordship, and in this ITI, your lordship, we have all trained ourselves, your lordship, by getting admission. Now,
Yes.
your lordship will kindly come to page 39. And your lordship will kindly see, this is a prospectus issued by them. The Industrial Training Center, Guwahati, your lordship will find below Assam State Transport Corporation. And your lordship will kindly come to page 41.
Yes,
Last line, your lordship. Here it says, your lordship, ASTC may absorb few of the successful candidates,
depend upon vacancy.
depending upon the vacancies and requirement of ASTC, your lordship. Now, this was the, your lordship, is a terms, your lordship,
So-
mentioned in the, and
so-
your lordship, subsequently we passed, your lordship.
Okay,
These are your lordship,
Yes.
annexure 3 series
Yes,
are the
appointment.
provisional trade certificates.
where's the engagement?
I will show it, your lordship. Your lordship may kindly come to page 52.
Yes, engagement of the mechanic
Lordship.
apprentice. There are 11.
Lordship.
Your-
Altogether, your lordship, there are at different point of times, your lordship, different separate orders, your lordship.
17/8/2013.
Lordship, then 19/8/2013. Your lordship will kindly see the
2010 also.
lordship. Your
Huh?
lordship will see as
2010
approved by the
also?
MD.
2010 also.
Lordship.
2013.
Lordship.
Just like that, just engagement.
Lordship, your lordship, I will show that, your lordship. As approved by the MD, you are requested to engage the undermentioned ex-students of ITC Guwahati who have qualified in the test and interview conducted on 7/8/2013 at mechanic apprentice for a period of 1 year. Now, your lordship,
Where it is?
your lordship in the page 52, your lordship. As approved by the DSR,
Engage and them access to the ITC and who have fulfilled the test and interview conduct duration. Yes,
lordship.
these are, all these are, the ITI.
ITI from the institute, your lordship, run by the ASTC, your lordship.
Institute.
Now, your lordship will kindly
All
see,
50,
lordship,
all 50.
all 50. I have made a
50
statement, your
petitioner.
lordship, and no denial about that, your lordship,
Okay.
in the affidavit.
Then,
Now, your lordship will kindly come to page 61, your lordship, page 60, your lordship.
yes.
That is the your lordship has already gone through this, your lordship, vacancies, your lordship, that they have, your lordship. These are all resultant vacancies of mechanics, your lordship. That means, your lordship, vacancies are there, your lordship, in which we are appointed, and your lordship will find at serial number for Guwahati 11, and your lordship 86. That in ISBT, that is the all, your lordship,
You are which place? Which serial number?
is, your lordship, in 4 and
CW.
11, your lordship.
Huh?
4, 5 and
What?
11, your lordship.
Guwahati, city service,
Guwahati, city service, and
CWS.
then CWS, your lordship.
50 mechanics.
Lordship,
Post is called mechanic.
lordship. Now your lordship will kindly come to page 61.
Yes, what is this?
Here it says, your lordship, second paragraph. The controlling officers have submitted their recommendations favorably for most of the trainee mechanics and trainee foremen in their performance list. Some of the artisans are not recommended by them for their unsatisfactory performance and poor attendance and very poor conduct as mentioned in their performance list. It is also reveals from the performance list that these artisans have been performing in ASCC as trainee for a pretty long time. Some artisans who have been engaged during recent past and have been working satisfactorily without any regular remuneration, their names have also been recommended by the controlling officers. Accordingly, your lordship will find, your lordship, that there is an interview. First of all, your lordship, there is an, your lordship, institute run by the ASTC.
Any advertisement?
Yes, your lordship,
Any advertisement?
no, your lordship, there is no advertisement as such, your lordship, that is there, your lordship, that they have been appointed contractual. But although there is no advertisement, your lordship, there is an interview, your lordship, as revealed by their own letter, your lordship. Now, there is a resultant vacancy in which we were appointed, your lordship. Our performance, your lordship, has been, your lordship, they have verified, your lordship, assessed, and on the basis of that assessment, your lordship, we are allowed to continue for around, your lordship, 10 years, your lordship, by the authorities, your lordship. Now the point is, your lordship, and your lordship, page 61 very clearly says that, your lordship, there is an assessment of the performance, and those who are not, performance is not up to the mark, they have not been, your lordship, allowed to continue. That is very clear, your lordship. Only thereafter, your lordship, they were allowed to continue, and they have been continuing as such, your lordship, till date, till, your lordship, their termination issued by the authorities in 2023, your lordship.
This is what? This is the resolution.
Yes, yes, your lordship, resolution, your lordship.
The view of increase of plate strength of the calculation where you are ready?
Your lordship,
Where you were reading?
page 61, your lordship has read, your lordship.
May engage schedule hands based
Lordship.
on the bare minimum requirement of the should be require equivalent understanding. I think other day we have seen it. already.
Lordship, your lordship has seen
Yes,
it.
we have seen it.
So your lordship,
Any new at a point you would like?
no,
to
your
make?
lordship, that's what I wanted to point out, your lordship, that these appointments, your lordship has gone through various appointments, your lordship. Some, your lordship, appointed as security guards, your lordship, the appointments they were made, appointed, your lordship, these persons, your lordship, separate appointments for separate categories of persons, separate interview, separate criteria, your lordship. Now, your lordship, what they did, your lordship, they, by passing a cyclostyle order in respect of all the petitioners, your lordship, have removed them from the service, your lordship. Can they do it, your lordship?
They're convenient.
No, that is convenient for them, your lordship, but convenience of them.
700 employees.
Lordship, that is what, your lordship. At the end of the day, when the service of each of the appointees are different, your lordship, or each group of the appointees are different, they will have to, your lordship, make certain enquiries, your lordship, in respect of them, your lordship. And after arriving at some finding, they will have to pass order by giving at least a notice, your lordship, to say that this is what we have found against you. and-
That I have, that your colleagues have, senior colleagues have also. put.
Lordship,
Any additional point?
no, your lordship, these are the points, your lordship, and your lordship will kindly see one, that judgment, your lordship, has already gone through Jaggo, your lordship, and one paragraph of that Jaggo I want to place, your lordship.
Para
39 is it, no? There are 26, your lordship.
We've gone through,
25, your lordship.
we've gone through it other day.
25 probably your
Gone
lordship
through.
has not gone through your lordship.
I'll go through everything.
Para
We'll
20
go through.
lordship. This is your lordship. It clearly says your lordship that they cannot extract the service in this manner, your lordship. And then one fine day they say that your lordship, you are no longer in service. That cannot be your lordship. As a
But you also had the knowledge, it's a contractual service.
yes, your lordship, it is contractual, but contractual will have some terms, your lordship. And if that terms is there, your lordship, they will have to go by that. They will have to issue a notice, your lordship, at least say. And therefore, your lordship, and your lordship will kindly note, there is no, there is in the order, they have not come up with any plea that they will go for regular selections, your lordship.
Suppose if the notice is issued,
Lordship,
what difference would make?
that will make your
They have
lordship.
already taken a decision.
No,
It
that,
is just, it was a mere formality.
no, that will not be your lordship. Why that will not be your lordship? Because then we can show at
And
least that
contractual,
no,
natural
that
justice.
contractual is all right, your lordship. But your lordship will kindly see the order of termination, your
Yes,
lordship.
yes, okay.
There is some findings, your lordship, that our appointments are illegal, your lordship.
Yes.
There is no recruitment procedure followed, your lordship. That finding completely, your lordship, the
On contrary,
yes, your lordship, that's contrary in view of the fact that there is an interview, at least, your lordship. An interview, your lordship, so far as these petitioners are concerned,
so what do we want?
at least, your lordship, till they, your lordship.
Okay, ultimately,
Lordship.
till the final
Lordship, they come
recruitment,
up with-
regular recruitment is
Yes,
complete.
they should have been allowed to continue, your
So
lordship.
is there any stay? I mean, is there any interim order?
No,
operating
so far
in your
as,
favor?
so far as in our cases, there are no interim orders.
Which case it was operating?
Only in one
Your
case.
case, you are still
working.
you are still working.
Working.
Okay, okay.
In her.
We are the only three who are continuing to work.
Others,
But I'll dispose of it in a common, I mean, obviously when common order, I think it appears that I'll have to look into each writ petition.
Lord,
Because ultimately prayer is still the regular.
Lord.
We cannot stop that
Lord,
regular
we cannot,
I mean,
Your Lord, we cannot.
selection process.
Yes, your lord, that's,
But in these areas, I think whoever is still are still continuing,
Lord.
maybe allowed, but the rest may not be.
Because,
due
but your
to
lordship, if your
flux
lordship,
of time, may not be possible. Let me see.
lordship,
Anyway, but then I will not be able to dispose it of.
Lord.
AG is appearing, London
Lord.
AG is appearing. Okay. The same heard as London senior councils, as well as the London councils for the petitioners. No, we have completed their argument. Next para. On the prayer of MS So appearing on behalf of London Advocate General, I will state as let this matter be listed after 2 weeks. 2 weeks in a sense, as in when this court will keep it part hand. All right. Let this matter be listed after 2 weeks. As part hand.
Actually, no date will be fixed.
That will
Lordship.
not be fixed. As in when this court sits. we'll take it. In fact, I wanted to dispose of it this today.
But Lordship, that matter will continue, Lordship.
Is
in
the
court time.
problem? Or should we release from part hard? Not the part.
No, your lordship
It
says
will not be
substantially
proper, I
hard, your
think.
lordship.
We have spent considerable amount of
Lordship.
time.
Lordship.
Okay. After 2 weeks.
After 2 weeks. Details.
Practically, it will not be after 2 weeks. It will be after 6 weeks only. But it shouldn't say. You never know. I may be called back again. What?
Here, your lordship, they have filed an affidavit yesterday, your lordship.
What? Not yesterday. Day for yesterday.
Yesterday, your lordship. We have received a
What
copy.
remains here, sir?
No, your lordship will kindly see there is a
You are claiming for only 3 months.
lordship. 3 months is not important, your lordship. Important is your lordship. That's my right to be considered, your lordship. And we need to file an.
What they are saying?
They are saying that during my vacancy, that period, your lordship, there is no vacancy, your lordship. To that effect, your lordship, I have to file a reply, your lordship. And in
Even if there is vacancy, what's wrong? What's the? what's
because
the-
your lordship, Supreme Honorable Apex Court has held, your lordship, that for their fault, your lordship, an employee, when his promotion is due, cannot be, your lordship, I want to file a reply, your lordship. That's my right, your lordship, since they have filed an affidavit, your lordship.
I know you have a right to reply, but
Lord.
then in certain cases, why unnecessary? We are fixing this matter almost every week.
No,
every.
your lordship will kindly say, that's not my fault, your lordship. They have not come up with the affidavit, your lordship.
No, I have filed
on
it.
the
I have
prayer
filed
of-
They have
the
filed,
prayer of-
your lordship, that has not been tagged.
Mr. S. Borthakur, counsel for the petitioner submits that since he has received since the state has filed the affidavit only
Yesterday, your lordship.
yesterday, the IE, 0405, 06/2025. He may be granted a week's time to
Lordship.
file affidavit in reply. Praise the Lord. Let's give that 2 weeks.
2 weeks, lordship.
So as to enable Mr. Doctor to the person to file for the petition to file affidavit in reply.
Lordship. Deeply obliged, your lordship.
Would you say?